Please be seated. The sitting is resumed.
I now give the floor to Professor Pierre d'Argent. You have the floor, Professor. I thank you, President. President, members of the court, it is always an honour for me to take the floor before the court. And it is an honour to do so today, once again, to support the Gambia for such a serious and important case. I will be tackling the matter of the impunity of the masterminds and perpetrators of the clearance operations. Because, as you will see, it is deliberate and organised by Myanmar, this impunity shows its dolus specialis. It will be the focus of my presentation. Also, this very impunity amounts to a sustained breach of the obligation to punish acts of genocide, and Ms. Jones will speak to that tomorrow. Mr. President, because a breach to the obligation to punish genocide can be at issue only if genocidal acts have been committed, Myanmar purports that Gambia's reasoning is logically flawed when it suggests that impunity is an indicator of dolus specialis, whereas it is up to the applicant to establish that genocidal acts have been committed, which suggests the existence of a very intention, or require, rather, the existence of such an intention. Members of the court, the Gambia naturally sides with the court's jurisprudence and agrees that the obligation to punish genocide can not be breached if there is no genocide. However, when the Gambia alleges that Myanmar's deliberately organised impunity of the members of its military involved in clearance operation is a key factor allowing to come with even greater certainty, were that to be necessary, to the conclusion that it possessed genocidal intent, when it says this, the Gambia's logic is certainly not flawed. Quite the contrary. Our reasoning here is common sense, just as is that of the UN's fact-finding mission, when it took it on and considered that the absence of credible criminal prosecution, not even on the basis of common law provisions, to be the seventh and final indicator of genocidal intent. Indeed, members of the court, as you know, enacting punishment is an attribute of sovereignty and a sovereign prerogative par excellence. Therefore, not to punish when there are clear reasons to take legal action undoubtedly shows the will, the intention of the highest level of the state. The former agent for Myanmar in this case, who is now a prisoner of the junta, she understood this full well, since she said before you, and rhetorically, the following question in the hearing for provisional measures, and I quote her.
On the part of a state that actively investigates, prosecutes, and punishes soldiers and officers who are accused of wrongdoing.
End quote. Mr. President, members of the court, the parties actually agree on the starting point of my analysis, and that is that Myanmar's constitution provides that members of the armed forces can only be subjected to legal action and punished by military courts. What's more, the Commander-in-Chief of the Armed Forces, who was also the head of state, General Min Aung Hlaing, is the supreme judicial authority within the Tatmadaw. His decisions when it comes to military justice are definitive and without appeal. What's more, the Tatmadaw's military justice system is well organized, and once again, I quote the former agent for Myanmar.
Advocate General in Myanmar is by all standards well-resourced, with more than 90 staff and a presence in all regional commands throughout the country.
In other words, the military justice system is in the hands of the military, and that system is fully capable of enacting its authority everywhere where the armed forces are deployed in the country. And thus, as you have just heard Ms. Alamin say, the highest-ranking magistrate of the army, Judge Advocate General Aung Hlin Dwe, went to northern Rakhine State in 2017, not to inquire, but to aid in the concealment of evidence of the atrocities committed against the Rohingya. Members of the course, Myanmar's setting up of a veritable impunity system which reveals its dolus specialis becomes clear when we analyse its behaviour chronologically. And here I would distinguish between three periods of impunity. The first period of impunity starts during the first wave of clearance operations and continues throughout the time period between the two waves of clearance operations. The impunity that followed the first wave guaranteed to military staff who would take place in the second wave that they would be able to take part in it without their having to fear any repercussions. A second period of impunity started at the beginning of the second wave of the operations on the 25th of August 2017 and ran up until the institution of the present proceedings on the 11th of November 2019. Finally, there was a third period of impunity, or rather there is one. It started with the season of the court and runs up until today. Myanmar's behaviour during this last period was of course tainted by the present case, since the respondent naturally wishes to appear before you in the best possible light, whereas its fundamental position has not changed in the slightest. Mr. President, members of the court, Myanmar does not dispute that it commissioned no inquiry and initiated no criminal prosecution against members of its security forces involved in the first wave of clearance operations while they were happening, that is to say, between October 2016 and February 2017. This impunity continued between the end of the first wave and the beginning of the second wave in August 2017. However, already during this period, by setting up so-called commissions of inquiry, which were smokescreens, Myanmar tried to put up a front for the international community, which was moved, quite rightly, by the indiscriminate violence that had been waged on the Rohingya. On the 26th of October 2016, the Rakhine State Parliament set up a commission of inquiry made up of 11 members of the parliament of that state. Interviewed by the BBC on the 7th of November 2016 on the pervasive and well-documented rapes of Rohingya women during these operations, the president of this commission of inquiry, Mr. Aung Win, responded with clear disdain for the victims that such actions could never have taken place because, according to him, Rohingya women
dirty. The Bengali women have a very low standard of living and poor hygiene. They are not attractive. So neither the local Buddhist men nor the soldiers are interested in them.
The court will therefore not be surprised to hear that the report of the so-called Commission of Inquiry of Rakhine State, dated 27th November 2016, stated that no wrongdoing had been carried out by the armed forces and the police during the first clearance operations. At the same time, in December 2016, Myanmar set up yet another smokescreen under the form of the Commission of Inquiry on Mang Do. which was asked to shed light on the attacks of October and November of the same year that had targeted the Rohingya. Made up of 13 members, this commission was presided by General Mint Swe, who was the vice president of Myanmar at the time, and a former head of the Army Intelligence Services. All other members of the commission were appointed by the military authorities. Among them were the head of police, Brigadier General Zor Win, and a former general of Tatmadaw, Mr. Aung Chi. During the first meeting of this Commission of Inquiry, its president set the tone. Faced with critical reports stemming from international organizations, their job was to reduce their worries and to work swiftly. Thus, on the 3rd of January 2017, less than a month after it was set up, the Mungdo Commission published a brief intermediate report. The so-called attacks against the security forces of Myanmar were described in great detail. However, when it came to the external allegations, quote-unquote, according to which genocidal violence and rape had been committed by the security forces, the Commission simply and briefly stated, following official narratives, and all the while claiming to have carried out special investigations, this commission stated that the presence of the Bengali population, just as the supposed increase in the number of Muslim scholars and mosques are, and I quote,
of genocide and religious persecution in the region.
When it comes to accusations of rape, torture and arson, the Commission fully trusted the security forces. And I quote,
Responsible security personnel performing their duties in those villages submitted that they have been ready to take legal action against those who committed crimes if there was sufficient evidence.
For rapes especially, the Commission decided to allay the concerns of the international community, as its president had announced, and it stated, and I quote again,
Interviewed local villagers and women by using various methods and didn't find sufficient evidence to take legal action up to this date.
In actual fact, these interviews were completely biased. Witnesses were interrupted when speaking, and their words were distorted by the interpreters, as the UN's independent inquiry mechanism for Myanmar has clearly shown. The final report of the Mangdao Commission, who were not independent and they had a lack of an effective methodology, as was pointed out by observers, this report was filed on the 8th of August 2017. The Commission said it had carried out
Allegation of rape, torture, arson, human rights violations, discrimination, and even genocide in Muslim villages. Fin de citation.
End quote. Members of the Court, the report of this supposedly detailed inquiry only makes up 7 paragraphs, from the second half of page 8 to the beginning of page 12 of the report. I would encourage the Court to read those pages, which appear in Annex 149, Volume 6 of Gambia's memorial. It says there, systematically, that accusations made against the security forces could not be confirmed, that some allegations described in the same terms will continue to be looked into, and that for others action was taken
Sans autre précision.
with no further precisions, whereas further allegations would require further inquiries, but are not further detailed, and we do not know if they were carried out.
Quelques mois plus tôt, le 9 février 2017, à la fin de la première vague des opérations de nettoyage et sur suggestion de la commission de Mangdao, la Tatmadaw créa une prétendue commission d'enquête dirigée par l'inspecteur...
May I interrupt you?
Sorry. Yes, my apology. As I said, a few months earlier, on the 9th of February, at the end of the first wave of the clearance operation and at the suggestion of the Mongdol Commission, the Tatmadaw set up an alleged inquiry board headed by Lieutenant General A. Wynne, Inspector General of the Defence Forces, made up of 5 members, all members of the military. Between the 10th of February and the 4th of March 2017, that is over 23 days, the Commission claims it interviewed 2,875 inhabitants of 29 villages in Mangdao Township. On average, that is 125 villagers a day at the very least. That is truly extraordinary. In fact, it is either false or perfunctory. On the 23rd of May 2017, 3 months before the clearance operation resumed, the findings of the investigation were announced. 12 of the 18th accusations to be found in the flash report dated 3 February 2017 from the Office of the United Nations High Commissioner for Human Rights on the basis of interviews of Rohingya refugees in Bangladesh who had fled since the 9th of October 2017. 12, as I was saying, of these 18 accusations were totally wrong. The other 6 were
to false accusations and exaggerations.
No details were brought forward to substantiate these peremptory conclusions, yet the Commission of the Tatmadaw did bother to share these or a number of exceptionally serious facts which really required and deserved to be shared. I'll let you judge this. 1 soldier had used a motorcycle without the owner letting him do it, while another 3 individuals had been sanctioned for beating a village administrator. So there you have it. There you have it, members of the court. That is how Myanmar, on the eve of the second wave of clearance operations, that is how Myanmar handled the violence unleashed by its security forces in the first wave. Quite clearly, the highest authorities in the state and the highest army officials intended to cover up the abuses. In so doing, the authorities were approving them. But in giving impunity to the perpetrators in the process, it is difficult to state that Myanmar was not also sending a message that they would be fully covered by impunity in the second phase of operations that would be visited upon the Rohingya people. On the 24th of August 2017, that is the day before the beginning of the second wave, the Advisory Commission on Rakhine State, established by Myanmar and chaired by former Secretary General Kofi Annan, made its final report public. And as it had in its interim report a few months earlier, the Commission had insisted that the situation stemming from the first wave was in fact a genuine humanitarian and human rights crisis. And the Annan Commission was clearly not taking seriously the so-called investigations I just mentioned, but underlined that the security forces had to be held accountable for the serious human rights abuses and mentioned a significant risk of renewed violence.
Il n'est malheureusement guère étonnant que les recommandations de la Commission Annan en matière d'enquête et de lutte contre l'impunité.
It is not surprising that the recommendations of the Annan Commission were, as concerns investigations and the fight against immunity, were basically ignored by Myanmar, as you will see. Myanmar, in fact, claims and pretended to implement them, however. And on the 10th of July 2017, even before the Commission filed its final report, the government spokesman, who was Director General of the Office of the President, also stated,
From the international community, we say we are taking action in line with the recommendations of the Kofi Annan Commission. The Commission is serving as a shield for us. Was it not for the Kofi Annan Commission, the allegations would be much worse.
The message, quite clearly, was well understood by the members of the Tatmadaw. As you heard, they would redouble in ferocity in their destructive endeavour over the course of the second wave of clearance operation. And from the beginning of that second wave, 25th of August 2017, until the filing of the application on the 11th of November 2019, Myanmar did not really change its attitude as concerns impunity. And yet, over the same period, the international community repeatedly called on Myanmar to put an end to the abuse and the systematic impunity of Tatmadaw. More specifically, on the 11th of September 2017, the Human Rights High Commissioner called on Myanmar to end its current cruel military operations with accountability for all violations that have occurred. On the 6th of November 2017, the chairman of the Security Council of the United Nations stated once again that the importance of undertaking transparent investigations into allegations of human rights abuses and violations and to provide justice for victims. On the 5th of December 2017, the Human Rights Council, which, and you'll remember, established the IIMM in March of that very same year, the Human Rights Council, as I was saying, called once again on Myanmar to, and I quote, end impunity for all violations, in particular those perpetrated against persons belonging to the Rohingya Muslim community, end quote. At the same time, a number of states were calling on Myanmar to put an end to the abuse and to investigate in a credible and transparent manner, which clearly hadn't happened until then, and which was also condemned by a number of NGOs of repute. On the 22nd of December 2018, the UN General Assembly shared its, and I quote, grave concern at the findings of the Independent International Fact-Finding Mission on Myanmar, according to which, in September of that year, there is sufficient information to warrant prosecutions for genocide, as the mission had identified the highest Burmese military officials in this respect. Myanmar didn't act, or rather, it went ahead and went on with its diversionary operations, thus further strengthening impunity. On the 12th of September 2017, during the second wave of clearance operations, Myanmar established a committee supposedly tasked with implementing the Annan Commission's recommendations. This committee was made up of 18 members representing the government and the presidency. The committee published a 19-page report in June 2019. It stated, without further detail, that the police forces in Rakhine State were operating within the law and were investigating whenever violations occurred. The committee also stated that the Myanmar Human Rights Commission had received complaints and was investigating. The National Human Rights Committee is dependent on the military authorities, and it seems not to have conducted any investigation leading to prosecutions. On the 14th of December 2017, an advisory board made up of 5 international members and 5 national members was established to assist the national 18-member strong committee tasked with the implementation of the Annan Commission's recommendations. Amongst the members of the foreign or international members was Ambassador Bill Richardson, former US ambassador to the UN. He then resigned a few weeks after his appointment. He stated that he did not want to take part in a mechanism which he said was likely to be called upon to become a
quad for government policy.
A few months later, another member of the committee, Ambassador Gobsak Chutikul, a Thai diplomat, also resigned from the advisory board, having denounced in even clearer terms the hoax that all the commissions, successive commissions and boards established by Myanmar they had all been set up for show, all for show, as he said.
En octobre 2017,
and the show went on. On October 2017, the army was establishing yet another internal inquiry board on the second wave of military operations, there again chaired by General I Win. And the commission was once again only made up of members of the military. And once again, it showed extreme zeal and interviewed, this time round, no fewer than 3,217 villagers in 26 days. It filed its report on the 17th of November 2017, that is 1 month after the establishment of the board, and the board found, perfectly predictably, that all security members, up from the leaders to the privates, were aware and strictly abided by the orders and directives of superior bodies. Rather emphatically, this so-called inquiry board stated that there was no death of innocent people, that not a single shot was fired on them. And that, and I further quote, security forces did not commit shooting at innocent villagers and sexual violence and rape case against women. End quote. Yet, 2 months later, on the 11th of January 2018, the very same investigation board set up by the Tatmadaw had to backtrack on its peremptory denialist report. In the meantime, and as Mr. Jai said yesterday, Reuters journalists had revealed the killings of 10 villagers in Din. And as you heard, they may have been killed in revenge. The Armed Forces Inquiry Board further explained that as it was impossible to take 10 alleged Bengali terrorists all the way to police stations during the military operations, it was decided to eliminate them at the village cemetery. Following this massacre, 7 members of the armed forces were court-martialed and sentenced to 10 years hard labour. But barely 7 months later, they were pardoned by the head of state and released.
Chef de l'État. Cette grâce présidentielle, mesdames et messieurs les juges,
This presidential pardon, members of the court, comes in sharp contrast with the fate that awaited journalists of the Reuters agency who published the undeniable photographic proof of the summary execution of those 10 villagers. Photographic proof that you will find in tab 4 of your file. Myanmar arrested the journalists, and on the 3rd of September 2018, they were sentenced to 7 years of detention. This sentence was confirmed by the Supreme Court. It was only following massive mobilization by the international community that the journalists were freed on the 6th of May 2019 after having spent a year and a half behind bars. That is to say, twice as long as the 7 months that the killer soldiers spent in prison. To respond to the so-called false allegations that were growing after the work of the fact-finding mission, Myanmar set up on the 30th of July 2018 an independent commission of inquiry. In actual fact, this commission was absolutely not independent from the government. Its very mandate stated that it was charged with inquiring about human rights violations, and I quote, following the terrorist attacks by the Arakan Rohingya Salvation Army. The president of this commission set the tone when she said, and I quote, "There would be no seeking of accountability. There will be no blaming of anybody, no finger pointing of anybody, because that wouldn't achieve anything. We wouldn't achieve anything by that procedure, and that would only give rise to quarreling." The president confirmed that interviews were carried out in the presence of security forces. What's more, one of the 4 members of this commission, Mr. Tun Tet, was the head coordinator of the Union Enterprise for Humanitarian Assistance, Resettlement and Development in Rakhine, and had supervised bulldozing of Rohingya villages. Before joining this so-called Commission of Inquiry, so-called Independent Commission of Inquiry, he had stated in March 2018 that Myanmar, and I quote, had a clear conscience, and that in his country there is no such thing as ethnic cleansing and no genocide. In sum, this is Myanmar's response to the atrocities committed in the second phase of the clearance operations. I now come, members of the court, to the third period of impunity, that which started when the court was seized. The efforts of Myanmar may appear to you as those of a state wishing to abide by its obligations to inquire and prosecute, but if we look at this, we find that these efforts can be unmasked and taken apart. What matters here, it's not the different condemnations of or sentencing of so-called terrorists. What matters is the prosecution, or rather lack thereof, against members of the forces, of the security forces. And we should look on one hand at its police officers and on the other at the military for their behavior in the clearance operations and not in other contexts. Regarding the police officers, Myanmar explains in the final report of its Independent Commission of Inquiry that it set up in January 2020 the Criminal Investigation and Prosecution Body. In its first report following the order of the court in January 2020, Myanmar pointed out that amongst the 139 cases identified by its Commission of Inquiry, 23 bore on members of its border police. This figure hasn't changed since. That was nearly 6 years ago. The evolution of the status of these 23 cases is presented in the semestral report of Myanmar. The tally of the 5th report in May 2022 has remained identical up until the latest report in November 2025. And here's the outcome. 7 inquiries that were ended for lack of evidence. 8 inquiries closed because the accused are allegedly on the run. 6 inquiries, presumably continuing since May 2023, but with no news about them, and 2 cases leading to sentencing. These 2 cases only had to do with lack of discipline. The punishment given to the policemen was a mere loss of 2 years of seniority for the purpose of calculating their pension. And that is just for the prosecution of police officers since the seizure of the court.
As concerns prosecution of members of the armed forces, the Independent Inquiry Board identifies at most 13 serious incidents. The first one, identified by Reuters journalists, concerned the massacre of the 10 villagers in Indin. I mentioned that, and you know that all eventually led to the pardoning and releasing of the servicemen 7 months after the beginning of their sentence. Second incident, the village of Gudapin, which Mr. Njai mentioned yesterday. 18 days after the application by Gambia was introduced, a court-martial rather conveniently heard the case relating to these facts dating 2.5 years. the court-martial sentenced a junior officer to 1 year in prison for breaches of the rules of engagement. One officer was also sentenced to a year for breaches of duty as a superior, whereas a higher officer was also sentenced for breaches of duties of command and lost 1 year of seniority for the calculation of his pension. In its 2020 report, Myanmar also indicates that it started investigation for the crimes committed in Chutpin and Mang Nu, which Mrs. Ho and Ms. Gum mentioned and described yesterday afternoon. As concerns the events in Mang Nu, the investigation led to the sentencing of one officer for breach of duty, which meant that he lost 1 year's pension right. 2 other junior officers were sentenced to 1 and 2 years in prison for robbing Rohingya women and doing so while resorting to violence. The 565th Infantry Battalion was fully and collectively cleared of any involvement in the incident at Tang Bazar in the vicinity of Mang Nu. The investigations relating to Chutpin have not led to any prosecution. I suppose that means these are allegedly still active and since its third report in May 2019, when not referring to the pandemic, the retiring of the lead investigator, or the security situation, Myanmar explains that the witnesses must first be repatriated so that the investigation can move forward. Well, you may wonder, however, why no members of the military were interviewed, and have been till now. Mr. President, members of the court, can I quote once again the former agent of Myanmar?
State that actively investigates, prosecutes, and punishes soldiers and officers.
The question then was a rhetorical one. You now know what the answer to that question is. You will draw the conclusions, the right conclusions. Myanmar didn't actively either investigate, nor truly prosecuted, nor really punished the many soldiers involved in these operations of unprecedented destructive cruelty. And at all times, Myanmar ensured the full impunity of the masterminds of the abuses. Myanmar was therefore indeed driven by genocidal intent. This conclusion, members of the court, is reinforced by the fact that Myanmar, rather than prosecuting and punishing them, Myanmar has in fact promoted some of these officers involved in the clearance operations, especially the officers commanding the units responsible of the worst sexual offences, as the IIMM highlighted. I'd like to thank the court for its kind attention and request, Mr. President, that you call Mr. Suleiman to the podium.